Before your pretrial deposition, your attorney specifically asked you whether you had any notes, diaries, or recordings with any of the doctors who treated you. And you said, absolutely not. Now, the next day, when you are being questioned by the defense attorney, they ask you the same exact question. Mr. Jones, do you have any notes, diaries, or recordings of any physician who treated you? And you answer yes. What happens then? Would you like to know what happens? Come join me for a walk through this beautiful area, and I'd like you to guess where I'm shooting video today. It's a magnificent area, and if you notice the beautiful ocean behind me, there's some beautiful ships in the background there. Leave a comment below. Let me know where you think I'm shooting video. Okay, so now, you told your attorney during preparation that you had no notes, you had no recordings, you had no audio, you had no video of any conversation you had with any of your treating doctors or hospital staff. And now, during the course of being questioned the next day by the defense attorney asks you a very simple question. Mr. Jones, do you have any notes or audio recordings or video recordings of any conversation you had with any of the hospital staff or any of the doctors who treated you? And you said, yes, I do. And in response, your attorney does one of these, what? kind of looks. And now you begin to say, oh yes, I have a recording of Dr. Gonzalez. I have a recording with this hospital staff. I have notes about my interaction with this person and with that person. And now your attorney yells out, objection, let's take a break. So now your attorney takes a break, comes to you and says, what are you doing? You told me yesterday, when I asked you specifically, whether or not you had any notes, whether you had any diaries, whether you had any audio recordings or video recordings, and you told me very simply and very plainly, no, I don't. How is it possible that the next day you now remember having all of these things? And you know what she says? She says, oh, well, at the time that you asked me, I didn't remember that I had any of those things, but after you and I talked, I went back to check to see if I had any notes, and in fact, I found notes, I found recordings, and so now we ask, why didn't you ever share that with us? Why didn't you provide that to us when you first met with us so that we could now address it? Because now what you've done is you've opened up a can of worms. You've created a significant problem. Why? It's because your attorney is no longer prepared for what you just did. It's because your attorney now is at a significant disadvantage. And you, as the person being questioned, are now at a significant disadvantage as well. Now you might be saying, I don't understand. If the defense goes ahead and asks that question, and they will, and now you turn around and say, yes, I have all of these notes, I have all of these recordings, I have every detail about my interaction with this particular person at the hospital, as well as with every interaction I had with this doctor. And by the way, your attorney asks, hey, did your doctor know and did the hospital staff know that you were recording them without their permission? And your answer is no, of course not. This is all being done secretly or surreptitiously. That adds another layer of complexity and a little bit of a problem. All right, so let's get back to the more basic question. Why is it a problem now for you as the injured victim if you have all of these notes and diaries and recordings about your interactions with the various hospital staff and the doctors? I'll tell you why. Because you've opened up a can of worms. Anything that you have in terms of those notes, diaries, recordings, the defense is now permitted to look at. They're permitted to listen to. They're permitted to watch. And now they're going to analyze and scrutinize and go through every single document and every single notation that you ever made that you are now required to turn over to the defense, which means your deposition is now going to be exponentially longer than it otherwise would have been. Now the defense will get to question you about every tiny entry that you made in your notes. They get to question you about every single notation. Because of the fact that your attorney did not know about any of these things and did not have an opportunity to go through them initially, your attorney will likely tell the defense attorney, listen, I didn't know about this, so what I'd like you to do is to continue questioning my client to the best of your ability, and after she turns over those records and notes and recordings to me, and I've had a chance to go through them, then we will reschedule her to finish up those particular questions relating to these recordings and these notes. That's what should be done. rather than going forward or trying to exchange them now without your attorney having had an opportunity to review them and to discuss them with you. By not telling your attorney that you have these items, you have now done a disservice to yourself as well as to your attorney, because now he is not fully prepared because you have told him that you don't have these items, these recordings, these notations. Now, he's going to have to get them from you, exchange them with the defense. The defense will then have to reschedule your deposition and continue on for hours asking you about every single entry and every single recording that you made. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.